a problem, then and you wanted that problem to go away with them leaving the business, then that in itself would be constructive dismissive improvement. Banks and big businesses used to go through elaborate ruses where they literally would have a room 101 where if an employer made an appointment to see one of their staff in that room, that employee knew exactly what they were going there for. And then they would hopefully have a constructive conversation about what's it worth for me to go. And you would get situations where employers would just go, you know what, I'm just going to fire you. And I've got an offer in mind. If you don't take it, I'll see you in the tribunal and see if the judge has an understanding of why we've made that decision. So what David Cameron championed was the ability for an employer to have a grown-up conversation about how somebody was doing. And there is a safety mechanism in the Employment Rights Act. You're not supposed to use any form of duress. But in essence, if you can't get a resolution that involves that employee leaving, or maybe things move on and they haven't left, but the protected conversation is inadmissible. Now, originally it was intended, protected conversations were really more about performance and performance management and issues of minor discipline, not to be used in cases of gross misconduct, for example. Many employers would use it in that circumstance, unless you're Taiwanese, I think. But that sort of conversation, however, has become used pretty extensively, even in context of redundancy, for example, where somebody maybe is in a standalone role, or perhaps a company has already said, look, if we go down a process, you're one of 4 or 5 in a pool, but for this non-discriminatory reason, we've already done the numbers, we've already looked at the criteria that we're following, and for these reasons, we think you'd be the one that would be selected. Okay. We've got to lose 2 from 4, and I'm sorry, but you would be one of those 2. So, you know, it's an opportunity to cut the bullshit, cut the apparent sort of sham of any sort of consultation, get down to the business, and it might be that that individual will then just get a little bit more money than they were perhaps going to do if they push the employer right through the process that maybe took a month or a bit longer to do with consultation. So protected conversations have become a very, very useful tool. And I have to say, I mean, I draft several every week, you know, pretty commonplace that companies will, because nobody likes to, if a decision's already often been made, the idea of then pushing through 3-6 months. And of course, somebody's, you know, an employee, the letter will actually say, you know, we have a problem with your attitude. We have a problem for these reasons. Well, might be a reasons why there's a restructure, a redundancy on the horizon. We have this issue. It's worth investing some time in that first few paragraphs of the letter. You're meeting that individual anyway. But it's worth investing a bit of time in that letter because you're managing their expectations, you're highlighting your issues that you have with them, or the issues that the workplace is faring. I don't encourage my staff to simply go, there's the template, there you are, client, and leave it to the client. It's worth spending some time in those opening paragraphs because you're setting the scene. It's not disclosable. Very rare circumstances where it's disclosable. I think since they were introduced in 2010, 2011 or whatever, I've had one dispute where I was acting for an employee in a claim of constructive unfair dismissal, pregnancy related, and we had to have a hearing within a hearing. You have a preliminary hearing about arguing about whether or not that can be disclosed. And we were unsuccessful in that first instance, but we were successful on appeal to the EAT because the judge was a claim. But there is a mechanism in the Employment Rights Act for when, and say, cases of discrimination, it can be quite critical evidence, and it was in that case. But you'll have a hearing within a hearing in the context of dispute, because she'd gone from that to resignation, and there was nothing to explain the history in the middle, particularly. So that protected conversation was quite important. That was a try and forget Peninsula. So there is a mechanism. But, pretty much even just in the last week, there's been a case reported where an individual had been on long-term leave, illness, come back, faced a redundancy situation. The employer wanted to know within 48 hours their decision. They were assured that if they didn't accept the offer on the table, there would be a fair redundancy process followed, and there might be suitable alternative employment had they gone through that consultation. The actual statutory provision provides a mechanism for up to 10 days in which to actually accept an offer. The employer had actually only given 48 hours in which to basically go, yeah, I'll take it, before they actually went on with the redundancy consultation. The employee sought to claim that that was unfair, that was not in the spirit of the statutory provision. Lost at first instance and went to the Employment Appeals Tribunal on the issue of whether or not that was disclosable in the context of the wider claim, and lost at the EAT as well. Tribunal found that on those facts, the employer had not been unduly unreasonable in the time frames that they've given, or the use of protected conversations. So it's just helped reinforce how useful a tool they are for employers, and I definitely recommend their use.